Hi, this is going to be a jury charge at 200 words a minute. Ready? Ladies and gentlemen, all of the evidence has been presented and we've reached that time when you are to perform your primary function. That is, you are to consider the evidence and, if after deliberating, if at all possible, to reach a verdict. Before doing so, it is the obligation of the court to instruct you as to the governing principles of law. Now, you don't have to sit on the edge of your seats and think you're going to hear something that's unfamiliar. The court is going to repeat much of what you've heard already, and then it will tell you very briefly what it is the state must prove in this case, and then how you go about returning a verdict. None of it will be difficult to grasp, so you can relax. The defendant, Darius Smith, is charged with being a certain person not to possess a weapon, it being alleged on September 5, 2012, that having previously been convicted of a crime, he did possess a firearm, that is, a pellet gun, in violation of the law. The court reminds you that an indictment is not evidence of a defendant's guilt. It is merely a formal charge that brings this matter before this court for your determination as to guilt or non-guilt. The court reminds you that it is not a victim who brings the charges to court. There's no victim that brings them. Rather, it's the grand jury which does so by way of an indictment. Here, the judge and the jury have two separate and distinct functions to perform. It is the duty of the court to instruct you as to the governing principles of law, and by virtue of your oaths, you are obligated to follow that law. On the other hand, you are the sole and exclusive judges of the facts in this case. It is the jury which determines the weight of the testimony, the credibility or the believability of the witnesses, the inferences to be drawn from the credible testimony, and it is the jury which, after a careful assessment of all of the evidence, returns a verdict. In your deliberations, speculation, conjecture, or other forms of guessing should play no role. During opening statements and during summation, counsel have made reference to anticipated proofs or evidence presented during the course of the trial. The court instructs you that any comments made by counsel concerning the evidence, or by the court for that matter, are not binding on you. And that is so because it is your function, not counsel's, not the court's, to determine what the evidence is. Neither the court nor counsel can tell you what the evidence is or is not. We can only state our recollection. If the court or counsel's recollection of the evidence does not coincide with your own, please be advised that there has been no intent to mislead you. It just means that one or more of us failed to hear the evidence as you heard it. During the course of the trial, motions and objections have been made by counsel. Very few, but there have been some. As jurors, you are bound by the court's ruling, and any evidence excluded by the court must be ignored by you and not considered in your deliberations. The court's actions and rulings should not be an indication to you how the court believes this matter should be resolved. The ultimate decision in this case is yours. It's not the court's. Also, the fact that the court may have asked a question or two of a particular witness should not indicate that the court holds an opinion about that witness's testimony. Again, it is for you, the jury, not the court, to weigh and evaluate the testimony of the witnesses and the credibility thereof. So, too, any remarks made by the court to counsel, by counsel to the court, or between the attorneys are not evidence in this case and should play no part in your deliberations. At the beginning of the trial, we discussed 3 overriding rules that you would hear repeated, and you're going to hear them for the last time. They deal with the presumption of innocence, the burden of proof, and the standard of proof, which is beyond a reasonable doubt. The defendant, Mr. Smith, has throughout the course of this trial been presumed to be innocent, and that presumption of innocence remains with him in the jury deliberation room, unless the state has proven the charge beyond a reasonable doubt. The burden of proof rests with the state. The defendant has no obligation to prove his innocence or to present evidence. Rather, the burden of proof rests with the state. Unless the state has proven the crime charged beyond a reasonable doubt, the defendant is entitled to be found not guilty. Now, what is a reasonable doubt? A reasonable doubt is this. Well, in the first place, let's discuss the fact that maybe 1 or 2 of you had previously served on a civil jury. The state has the burden of proving guilt beyond a reasonable doubt, and some of you may have served as jurors in a civil case where you were told that it is necessary to prove only that a fact is more likely true than not true. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. What is a reasonable doubt? A reasonable doubt is an honest and reasonable uncertainty in your mind as to the guilt of the defendant after you have carefully and fully evaluated the evidence. A reasonable doubt may arise from the evidence presented or from a lack of evidence. It is a doubt which a reasonable person hearing the same evidence would have. In this world, we know that there are very few things that are known to us with absolute certainty. In criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you are not firmly convinced of the defendant's guilt, you must give the defendant the benefit of the doubt and find him not guilty. Proof beyond a reasonable doubt is proof, for example, that leaves you firmly convinced of the defendant's guilt. How do you evaluate the testimony of witnesses? When considering the testimony of witnesses, you may wish to take into account some or all of the following: the interest or lack of interest that any witness has in the outcome of the case, the bias or the prejudice of a defendant, if any, the witness's mental capacity of knowing that about which he or she speaks. You may consider the reasonableness or unreasonableness of the testimony. Any prior inconsistent statements of a witness may be considered. The manner in which the witness testified, the demeanor of the witness on the stand, the defendant's willingness or reluctance to answer questions, and the inherent believability or lack thereof of the testimony presented during the course of the trial. It was 6 minutes. I said defendant one time instead of witness.